Hi there and welcome back. Today we're talking about probably the most confusing bit of Illinois specific law that actually touches on criminal, and that is the Safety Act or the Pretrial Fairness Act. There's been a great deal of discussion, and now that the law has been not only passed, but actually taken effect in September of 2023, we now have the better part of about 8 months of experience with the law in practice, actually going to court and dealing with the law. I believe it's appropriate to speak on how it's working and then how it affects my clients and what to expect if you're ever at a detention hearing. As a first step, the Safety Act is certainly a lot more than just talking about cash bail or the elimination of cash bail. The Safety Act actually touches on a number of different things. But for my clients, anybody who's actually been charged with a felony or a detainable offense, the only thing they care about is what are the factors that the court has to make a determination on, and then when am I going to be detained, if I'll be detained, and if I am detained, how can I get back out? Those are really the key questions. So really to touch at the beginning, there are some reforms that relate to police as far as allowing people to report misconduct, how misconduct records are supposed to be maintained, and among other basic kind of behind the scenes police reform. It's not something that my clients would have an experience with on a day-to-day basis. It's not something that I deal with on a day-to-day basis, but it is included in the law. There were some amendments that touched on specific offenses and changing the sentencing requirements and some mandatory minimums. That change that only touched on a few different types of cases, but the big one, and really what this video is going to be about, is the elimination of cash bail and detention hearings. That's what we're here to talk about today, and what to expect, what happens at a detention hearing, what happens if someone is detained, the subsequent options that individual may have, and then what may happen even if you are not detained, if you're not put in jail. So as a starting point, there are a great deal of cases that are detainable. I can't sit down and actually go through every one of them. I have a flow chart and a form that outlines all the possible types of offenses that someone may be detained on. And as a starting point, detention or being detained. What that means is that while the case is pending, while you're in the pretrial stages, that you've been charged with an offense, but you haven't yet gone to trial, you haven't been convicted yet, the court is making a determination on whether you should stay in jail and be held at the Cook County Department of Corrections or your local jail, your county jail, or if you should be released and allowed to go back home, and then under what conditions. If you're not going to be in jail, what rules are being put in place to make sure that you come back to court and to avoid picking up new charges. As a general rule of thumb, just about any felony that you can think of, I would expect to be detainable. There are some carve-outs, some exceptions where that may not be the case. Lower level offenses, low level misdemeanors, things that are under a Class A misdemeanor, Class B, and so on. You may be cited. You give a ticket and then instructed to come back to court, assuming you can provide identification. And if it's determined in the moment that you're not a flight risk or a dangerous individual. So expect most felonies, from even domestic batteries, gun possessions, drug possessions, certainly other forcible felonies like armed robbery and burglary and things like that. Those are all going to be detainable. And when I say detainable, it's because the state or the state's attorney, the prosecutor, could determine that they don't want to file a petition. They're not actually asking the court to hold you in custody or detained while the case is going on. In my experience, through about 8 months of this, the state is filing petitions on more than 99% of detainable offenses. Now, I think that's just a general rule of thumb. It's anecdotal from my own experience, but my expectation is that if a client is charged with an offense that could lead to their detention, the state's attorney will file that petition. They will ask the court to hold my client in jail. And then it becomes a decision of the court whether to actually put my client in jail or to allow them out and with what conditions. That request or petition to hold a client detained happens right at the beginning of the case. In what used to be called first appearance or bail or bond court, it's now called first appearance court. It's at that point where the state will file a petition. It's a single document that outlines why this individual should be detained, a brief synopsis of what the state believes to be the evidence that they have relating to the charge, and again, why this individual should be detained. At that hearing, the state will speak first. They'll make their argument. They'll go through what is called a proffer. Proffer is an description, an overview of what the state believes their evidence would be. They will also go through the criminal background of the defendant and argue why detention would be appropriate. Then it's the defense side who gets to go forward and explain their proffer, their version of the events or evidence, what they believe the evidence will show, even though this is at a very, very early stage. It's the first time you're in court. We get to give good mitigating circumstances, good information about the client, employment, education, family, ties to the community, lack of a criminal background, and so on. These are all things that we can talk about, putting my client in the best light possible. But then we'll also go through the other factors relating to detention and why detention is not the least restrictive means and why release is more appropriate. So the defense gets an opportunity to speak and argue and go through the factors that a court is supposed to consider when determining whether to detain or to release. Those factors are, and we've really kind of crystallized this now, there are four main things that the state has to prove by clear and convincing evidence. And I'll take a moment to talk about clear and convincing evidence right now. That is certainly lower than proof beyond reasonable doubt, but it's also more than just probable cause. It's this in-between standard where it's a high standard, but it's not the highest. It's also not the lowest. They being the state are supposed to point to articulable facts, not just hunches or guesses or assumptions or making generalized statements. They are to be pointed to specific evidence that they have in their case, evidence about a defendant's background and so on, to show that that the case is strong against the defendant, that they're dangerous or a flight risk, and so on. So we have these four elements that need to be shown by clear and convincing evidence. They have to be proven to the judge because that'll be the ultimate person who makes this determination. First, is this a detainable offense? That's binary. It's a yes or no. It's black and white. It either is detainable or it is not. So that's pretty easy. It either is it or isn't. Number two, the state has to, again, convince the judge by clear and convincing evidence that the proof is evident or conviction is likely that this defendant committed the eligible offense, that this is a detainable offense, and this is the person who's committed it, at least by clear and convincing evidence. The third factor, it's really a 3A and a 3B. 3A is that the state has to, again, show and prove beyond or by clear and convincing evidence that the defendant is a dangerous person, that they pose a risk to society at large or a particularized person, that there's a very specific person that would be in danger, at least potentially, if the defendant is released. The 3B is that the client is a flight risk, that there is evidence of willful flight, that this individual, if released, if they're let go, they will not come back to court, that they will leave the courthouse and flee either the city, the state, or maybe the country. But the state, again, bears the burden in satisfying the judge, convincing the judge by clear and convincing evidence, either of 3A or 3B, that you're a dangerous individual or that you are a flight risk. The fourth factor, and this is one where there's been a good bit of debate and discussion, and some Court of Appeals opinions have already come through, is that even if the state can satisfy those first three elements, it's detainable, the case is very strong against this individual, my client, the defendant, that they've committed this detainable offense. They are either a dangerous person or a flight risk. Number 4 is there a set of conditions that is less restrictive than detention? Can the judge fashion a set of conditions and requirements that can ensure that this individual is not going to pick up a new case? They're not a flight risk. They won't hurt somebody. And there's a number of things that the court can look at. The most common example would be electronic monitoring, EM, or home confinement. Those terms are kind of loosely thrown around. They all effectively mean the same thing. And what that is there's hardware that's installed in both in the home and on the defendant, him or herself. It's a band that ensures that they stay within the home 24 hours a day, 7 days a week, and only allowed to leave under certain circumstances. By statute, a defendant is allowed 2 days a week, usually about 8 hours, to go and do life essentials. And we commonly call that essential movement. And what that is allows that defendant to leave the home, to go and buy groceries, to get their hair cut, to go and run other errands, things of that nature, so that they can get these things done even though they're otherwise supposed to be at home. One benefit of electronic monitoring is that, assuming there are no violations, that time that you serve on electronic monitoring counts as jail time, as custody time. So if a defendant is either found guilty or pleads guilty to negotiated plea agreement, that time that they're on EM, if it's a month or a year, and sometimes it's even longer, that time can be attributed towards whatever sentence that could be in place. So hypothetically, if a client was charged with a class 4 felony and they're facing 1 to 3 years in prison, and they actually have 1 year served or 6 months, depending on the type of offense, if it's served at 50%, they actually have served their entire sentence while in their own home, which is a nice benefit. You get to do that from your own home rather than being in custody. The issue with EM is that it is very restrictive. You may get those 2 days a week to go run those errands, but otherwise you cannot leave the home. You are stuck at home. You are not to go outside the door. You're not supposed to go on your porch. You don't go to your driveway. You don't do a quick trip back and forth to your garage. It's assuming this is an unattached garage. Those can be violations, and if you violate, you could go back into custody. Other potential conditions might be a GPS tether. It's another bit of hardware that a client would wear, and it's different than EM in the sense that GPS basically allows you to go anywhere you want to go, except for certain restricted zones. Those restricted zones usually involve when there's a complaining witness or a victim in a case, a domestic battery or a traditional battery and so on, that the state or the judge does not want you to go near that person's home, their place of work. If they're in school, don't go to where their place of education would be. But otherwise, you can go anywhere else that you would like or where you want to go. Whereas EM, there's very limited situations where you can actually go anywhere. You're otherwise supposed to be at home. GPS will allow you to go, for the most part, anywhere you want to go, except some certain restricted areas. There's also a curfew, which is kind of a less restrictive version of electronic monitoring, where a typical example of a curfew would be you're allowed to leave your home between 7 a.m. and 7 p.m., but between 7 p.m. and 7 a.m., you have to be home. So curfew would allow you to go to work, run some errands, typically Monday through Friday, but then you have to be back in home between those hours or it could be a violation. Other potential conditions might be drug or alcohol testing, pretrial services, where they want you to physically go in and check in at a location, either on a daily, weekly, monthly basis. You might check in via phone. Those are all possibilities. And then there are mandatory conditions, and that would be that naturally the defendant has to come back to all future court dates. That could be in person. In Cook County, there's still a good bit of Zoom court, meaning you have to appear to court, but you can do so from your phone or from your computer. You do it via Zoom. In most of the rest of the state of Illinois, as I understand it, in-person court is now the standard, at least under most conditions, meaning on your next court date, you have to be there. You have to show up to court. You need to be on time. That could be deemed a violation. That you're supposed to submit to any other orders of court. If the judge is telling you you need to go somewhere to do something, if you have to submit to what's called a buccal swab, it's where they swab the inside of your cheek. This is for DNA testing. If you need to go and be fingerprinted, if you need to do some other procedural thing, you have to abide by that. If the court tells you to do it, you have to do it. Naturally, and not surprisingly, the court will tell you you're not allowed to violate any other criminal statutes. Don't pick up a new case. If you pick up a new case, that could be a violation of your release conditions. And then, of course, if you were to move addresses, it's not that you can't move, you're allowed to move, but you have to inform the court or the clerk within 24 hours of where you're moving. The reason for that would be, naturally, the court wants to know where you are. But number two, and maybe even more importantly, the court needs to be able to get in contact with you. They need to be able to send you notices of when your next court date is, or if something gets moved, either back or forward. They need to be able to provide proper notice. And if you don't tell the clerk's office that I've moved addresses, that could be another violation, especially if it's determined that you were doing it purposefully to try to avoid allowing the court to know where you reside. There could be some other basic conditions here and there that a court might put in place, but those are the typical ones that I see. And that's if the court determines to release you in the first place. Because again, the alternative is the judge says, no, I believe the state met their burden. They've satisfied those 4 factors that we talked about earlier in this video, and you will remain in custody. A note, if for some reason you're watching this video, you have a loved one who is in custody right now, they've been detained, don't give up all hope. There certainly are occasions where clients who are initially detained are released later. We learn more about the case. There's more discovery, which is another word for evidence, that comes forward that changes our view of the case. It seems to weaken the state's case. There could be other arguments that we could make that maybe weren't made at the initial court appearance, or if you're hiring me after going to the first court appearance and you're looking for new counsel, there are fresh arguments that can be made, presenting your loved one in a better light. There certainly are things that can be done. Under the statute, an individual's detention status is to be reviewed at every subsequent court date. Now, that being said, we would like there to be, the phrase would be a change in circumstances. And what I mean by that is, between the last court date and this next court date, the one that we're in front of the judge for right now, is there something new? Can I actually tell the judge, listen, there's some new evidence. You didn't hear this before, or you didn't hear this argument before, and this is persuasive, Your Honor. This is why you should change your opinion. Or if this is a judge who's reviewing the case after first appearance court, it's your assigned judge now who's presiding over the case. Your Honor, these factors were not considered. These facts, this information was not presented to the first appearance court judge because we just learned about them, or the previous attorney didn't do a very good job at that hearing. Your Honor, consider these new factors. It may change your mind about whether the defendant should be released or not. So that's the first part. If somebody's detained and you're watching this video for a loved one, this is something we can help you out with. The second side, the other side of that coin would be if you're released right now and you're watching this video for yourself or you're watching it for a loved one and they're home with you and they're out, they're on electronic monitoring or they're on GPS or whatever it may be, which is great, don't violate. Just because you're out right now does not mean you will remain out. If you violate your EM, if you pick up a new case, if you fail to appear for court, if you move addresses and don't tell the court and they find out about it and they believe that it's purposeful, that can be a reason to have you detained, that the state can file a violation of release and then you can be taken back in. And I've had cases go both ways. I've had people that were initially detained, released, and then I've had those who were initially released then later detained because unfortunately they caught a new case or they violated their electronic monitoring by moving without permission, things like that. At the end of the day, the Safety Act is doing exactly what it was designed to do. And that was level the playing field and make things not about money anymore. That under the old system, if you were wealthy, you could get even a high bond. Maybe you had to post $10,000 or $100,000. You could get out. You would be released. Whereas somebody else who didn't have the money and even just had to post $100 or $500 could not get out. So it was no longer about whether they were a flight risk or if they were dangerous or if they should be released at all. It really just came down to money. The new system levels that out. It has nothing to do with how affluent or wealthy you are, or the alternative, perhaps just how poor you are, or the lack of assets. It's about whether you should be released or not. Are you a safety risk? Are you a flight risk? And does your background indicate that you're dangerous or a flight risk? Those are the things that the judge is going to look at. I've dealt with literally hundreds of these types of hearings at this point. We've had a great deal of success in getting clients released, either at that initial court hearing or if we come in later on a case, because we at the firm understand the case law. This is something that I look at on an almost daily basis. There's new cases coming through because the Safety Act is still so new that the Court of Appeals, which is inundated with appeals, they're issuing their own opinions now, focusing the trial court level judges and then attorneys as well, we that are practicing under this law, to better argue and understand what these factors are and what should be persuasive in holding somebody and then what isn't, what doesn't rise to the level of clear and convincing evidence in making somebody detainable or that a judge holds them detained. At the end of the day, you want somebody who's an expert who understands this law, that understands the actual factors, the evidentiary burden that the state holds, and then has the ability to present your loved one or yourself in the best light possible, because that is the difference between fighting your case from the inside, and in cases specifically in Cook County, are not fast. Cases will take months and sometimes can go well over a year or more. That difference between fighting a case from the outside or fighting this case on the inside, it makes a huge, huge difference. Again, I thank you for taking the time to watch this video. I certainly hope it was beneficial and you learned something. If you have further questions about the Safety Act or anything that's related to criminal law, contact the firm or message below and I'll be sure to either do a video or contact you back directly so I can answer those questions. Have a great day.